start, we have heard learned counsel for the parties who have entered appearance sto. Having regard to the nature of the order proposed, we do not consider it necessary to issue notice to all the parties who are not represented sto. The matter arises out of selection conducted by the Karnataka Public Service Commission pursuant to notification dated 3/11/2011 for filing up 362 posts for the Group A and Group D in the state of Karnataka sto. Examinations were conducted on 22/4/2012 sto. Written tests for mains were conducted between 15/12/2012 and 16/1/2013 sto. Interviews were held between 1 April 2013 and 27 May 2013 Stanja. There were complaints of malpractices and irregularities in the conduct of examinations as well as the interviews sto. It was inter alia alleged that there were demands of bribes from candidates sto. The FIR was lodged against chairman, member and some officials of the KPSC sto. On receipt of the interim report of CID dated 10th September 2013, the state government on 15th December 2013 directed annulment of evaluation of written examination as well as the personality test sto. The KPSC, however, published the select list sto. The state government withdrew the requisition for appointments on 14/8/2014 Stanja. The above order was challenged by the successful candidates before the Karnataka Administrative Tribunal sto. The tribunal wide order dated 19th October 2016 quashed the decision of the state government and directed appointment of the selected candidates sto. Some selected candidates have been given appointments sto. The order the tribunal challenged was before the High Court sto. The High Court by the impugned order set aside the order of the tribunal sto. The High Court observed that appointment of ineligible, inefficient or persons of questionable integrity has serious adverse impact on the working of the government and is anathema to the rule of law sto. Best selection to the government service was the mandate of the Constitution sto. No right accrued to candidates merely by being in the select list sto. No right tribunal was in error directing appointment of persons validly of whose selection was seriously doubted by the government Stanja. We find that the High Court has referred to material on record in the form of call details between candidates and members of the KPSC sto. All the members who interviewed the candidates awarded exactly the same marks to the particular candidates sto. There was no objective assessment by individual members sto. There appeared to be extraneous reasons in awarding the marks sto. 566 candidates were awarded same marks which appeared to be predetermined sto. Digital video recorder in the KPSC building was replaced to destroy evidence sto. In this view of the matter, we do not find any ground to interfere with the view of the High Court that the selection could not have been sustained sto. If the selection is found to be tainted in any manner, it is always open to the concerned authority to annul such selection to maintain purity of the selection process. It may not always be necessary to segregate tainted and untainted candidates when the process itself is tainted. Moreover, at pre-appointment stage, decision to cancel the selection process can be interfered only if it is patently arbitrary, malified, or illegal. Over.